Welcome everybody to this seminar. This is actually a seminar that we hold at least once a month. We started, I think, 15 years ago, and is organized by the Department of Legal Theory here at the Stockholm University in Sweden. And so it was organized by me and Mauro Zamboni, professor in legal theory. Together with me are my colleague also Torben Spak, Maria Neve, and Katarina Fast-Lapalainen. Actually, the goal of these seminars that we have, as I said, at least once per month, is to somehow narrow the bridge between legal theory and the other legal fields. And it was, I think, 1 year ago, I was in Manchester for a presentation, and I was speaking with Jorge. And I thought, actually, we started to talk about his research, his book, and I thought he was a perfect candidate for our seminars because he's both fields is both a field of expertise is both in legal theory and international law. So I thought Jorge was really the perfect guest for us. So Jorge, once again, thank you very much for joining us. Briefly, Jorge is Dr. Jorge Emilio Núñez, is Argentinian. He has his law degree from La Plata in Argentina. Then he got his PhD in England, in Manchester, and now he's a lecturer, senior lecturer at the Manchester Metropolitan University in England. And he's here to talk about his latest book, that is Territorial Disputes and State Sovereignty. As you can see, the topic is very much a crossing over of legal theory and international law. This is why, in particular public international law, this is why this seminar we have organized in combination, is a joint seminar between the Department of Legal Theory here and the Stockholm Center for International Law and Justice. Also here is a center, also here at the Faculty of Law. Mark, would you like to present the center?
Yes, thank you very much. First, I would like to thank Katarina and Mauro for organizing this and Dr. Núñez for the presentation you're going to give us. I was asked to briefly present the Stockholm Center for International Law and Justice. So I'll just briefly show here our forthcoming events. It's on our website, Stockholm Center for International Law and Justice. So here you can see the upcoming events. We have with Professor Westman the 1st of October and the 6th of October with Andrew Clapham on armed groups legislating for rights for detainees. We also have a new page for research where you can read about current research projects. Here at the end you can read about what's going on. And finally, I would like to advert next year, we're hosting the European Society of International Law annual conference. It will be held the 9th to the 11th of September. And the theme is changes in international lawmaking, actors, processes, and impact. So thank you for giving me the opportunity to talk about the center. And now I will hand over the floor. Thank you.
Hey, thank you very much, Mark. Now the advertising moments is over. I'll advertise the Department of Legal Theory, will advertise the center. Now the leader of the discussion will be Katarina, my colleague, Katarina Fast-Lapalainen. Katarina, you have the floor.
Yes. So first we are going to be happy to listen to Dr. Jorge Núñez. And we will have a 30-minute presentation first with a break for 5 minutes after around 30 minutes. We'll see, Jorge, how it goes.
I can promise.
And then after that, perhaps you have some concluding remarks to make after the break. And then after that, we will have a discussion, Q&As. And during the discussion, I can mention it now that we would prefer if you would use the raise hand button. If it doesn't work, use the chat function, of course, but we hope it's going to work out fine for you, and I will give you the word when it's your turn. Okay, Mauro.
Thank you. Just one thing, just so let you know, we will start when Jorge will start the presentation, we will start to record his presentation. So if you want to disappear from the screen, no problem. We will only record Jorge presentation. We will not record the Q&A moment. So just so to let you know for
Yes.
Of personal integrity. So I will start now the recording. So if you want to disappear, no problem.
Mauro, before I forget, I've already started recording because it was part of the presentation. You, Katarina,
Okay.
and Mark. Yeah.
So,
Don't
so
worry.
we have violated a couple of Swedish laws, but I don't know.
You can blame me.
I don't know. That's
Well, we consented, so it's okay.
Okay, we can cancel it. Okay, perfect. Thank you. The floor is yours, Jorge.
Thank you very much. First of all, thank you, Katarina, Mauro, and Mark. Thank you very much for the invitation. Stockholm, the Department of Law, and Uppsala, if I'm right, the Department of Philosophy as well. So thank you very much for the presentation, and allowing me to present. And gracias, obrigado, namaste to all the, the attendees today. I'm conscious we have people from Peru, Mexico, Latin America, Asia, China, Sweden, of course, Europe, and several. David, I can see many friendly faces here, and people I don't know. So I'm hoping this is an interesting presentation. What I'm going to do today, I'm going to start sharing, my screens. And what I'm going to do today, because again, thank you for the kind presentation, Mauro. I am a lawyer. I have several degrees: notary public, international relations, one of my masters, and a PhD in law. However, I have been doing for many years philosophy, legal philosophy, political theory, and international relations. So the ambition today is trying to talk to all of us, regardless of our background, whether we are professionals or not professionals, whether we are judges or ambassadors, or simply people interested in international relations. Why I'm saying this? Because I had more than 10 years practical experience in criminal court justice back in Argentina. I've been teaching in many countries since 1997. And the lessons I'm going to try to share, because these are my lessons, life lessons, have to do with things I've learned throughout my professional and personal career from India to Argentina. So what you are going to try to, I'm going to try to explain today is my life lessons translated into books. My details, again, you can contact Katarina, she has my details. That's why I use my logo, it's not my ego. I don't have any ego here. It's simply, you check Dr. Jorge and you will see online my website. And I'll explain later why I have a website, because I work for charities as well. Please address me by name. Don't use my title, simply Jorge. That's why with Katarina and Mauro and Mark, simply, I say, by first names. What I'm going to try to do in 30 minutes, Katarina, I'm going to explain what we have now and what we've been having in international relations for decades. I don't see any revolution, intellectual revolution in international relations, and I'm not surprised. Territorial disputes are still going on in Kashmir, in Gibraltar, in the Falklands, etc. I'll talk about some cases later. We are not doing anything really to solve them. The vision I have and the 2 steps I've already taken. A book published in 2017. I'll refer very briefly to that one. And then the rest of the presentation will be about my latest book, 2020. Why I'm starting in 2017? Because they are linked together. And I'll explain later why. And the message that probably may come after the break, because that's a very personal, part of my conclusions and a personal message I'd like to bring as well, now that we have people from all over the world. The situation as we are now, and it's been, I'm going to, this I learned from India, the metaphor I'm using is the story of 6 blind men and the elephant. We have here Boris, Vladimir, Donald, Alberto, Imran, and Benjamin. These are blind men that somehow happen to bump into an elephant. They've never seen an elephant. They are blind and they've never touched an elephant. So the first of this person touches the elephant's leg. He feels the leg and he says, well, this is huge. It may be like a column. So an elephant may be in the shape of a column. One of the other deaf blind men touches the tail. This feels like a rope. So I'm sure, the elephant is very, very long and very slim. Somebody else says, no, I'm touching something else, the trunk. It's very wrinkly and very thick. It cannot be a rope. and somebody else touches the body. No, 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 this is not a column, this is not a rope, this is not anything else, this is a wall. An elephant has the shape of a wall, and so on. What I'm trying to do today is not complaining about Donald Trump, or Boris Johnson, or Alberto Fernandez, or the others, or not talking about political scientists, or lawyers, or any other profession. What I'm trying to show is, and that's why we don't solve these problems, is that we are all individually right in some part, yes? Whether we are from the States, or whether we are from India, or from the UK, whether we are political scientists or lawyers. However, we are all on the wrong because we don't communicate with each other, yes? We seem to have a common language, we don't. We simply use the same terms. What we've been having in international relations, and that's the philosopher in me, Mauro, the legal theorist / political theorist, we have unidimensional views. I'm taking two concepts. My work has to do with many concepts. I'm going to focus only on two: sovereignty and territorial disputes. We seem to think about sovereignty as an absolute concept. We seem to think about territorial disputes. One has to win, yes, to be very, very short. What I do with my work, and I've been doing for, I mean, it's since my childhood probably, it's my way of seeing things. And I was talking to one of my colleagues from Manchester Met, Kay, who is here last week. I'm changing the perspective. I'm not inventing anything. I disagree completely with changing the concept of sovereignty. I'm simply taking a different stand. I'm bringing a multidimensional view. Yes, whatever we see as unidimensional, I'm trying to convert in multidimensional. I'm not doing anything new. I'm simply recognizing what's there. And that's exactly what I do when I teach law, or when I do political sciences or international relations, and when I do my research as well. I am conscious that any kind of phenomena has to have to do with different elements or different facets, I call them. We may talk about a particular fact. That fact may be interpreted in a certain fashion, a certain form by political scientists, to put an example. That fact may be seen through the norms, one of the many kinds of norms, the law, as again, all legal theories, we may talk about different normative systems, religion, morality, and law. I'm only going to focus on law today. And those facts and those norms will be interpreted by the viewer or by the user. So, and I'm going to address examples later, but if I am the UK, in a certain time in history, I am going to see sovereignty as an absolute concept. Why? Because I'm extending my empire. And I'm going to see my peers, Spain and France, as equal, absolute sovereign. However, all the rest are not that sovereign. Yeah. So that's why, to me, whether sovereignty is absolute or not, or relative, has to do with an axiological choice. Why? Because sovereignty has always limitations, factual limitations and normative limitations. There is no absolute sovereignty. Even Bodin or even Hobbes accepted limitations, and I have papers written on that. The steps I've taken, in principle, two books published by an important publisher, and one self-published, what I tend to call my theory for dummies. You know, a very, very diluted version because I don't write for academic only. My work has to be, in a sense, proactive. I'm working for people. And my ambition, the day I go from this live into the next one, or you know, whatever comes later, is I'm trying to leave this world a bit better. That is why, whether I'm adding or not another line on my CV, that has been my lifetime ambition. So I'm going to talk briefly, 2 minutes, about the first step. The very first book, globally published by Routledge, had to do, I started from scratch. This is for philosophers, people interested in legal philosophy, political theory as well. This is highly, highly conceptual. I deal with Nozick, Kelsen, Rawls, and many, many others. I bring the Bible as well to prove that even God in the Bible is not absolute because it has a historical, you know, origin. And what I'm trying to do, and I'm going to not going to give too many details about this today, just to focus on the next one, has to do with seeing territorial disputes from an experimental point of view. Yes, my laboratory. I have what I call reasonable people in this ideal world. And these people have a dispute about a populated territory. And I'm asking them, to select a solution to that dispute. These people are not selfish. They are not self-centered. They think about themselves without being selfish. So I put a certain conditions. For people who are into legal philosophy, it's very similar, but adapted to the methodology behind Rawlsian theory. I'm not using, I don't agree with Rawls and his theory applied to the law of peoples, international relations. And we can talk about that in the questions and answers. I apply the methodology. The methodology is not even a Rawlsian, comes from Kant and before. It's simply applying that veil of ignorance or that ideal world into territorial disputes, and I ask these reasonable persons, reasonable agents, who do not know who they represent, that's one of the conditions I put, to decide who the sovereign is. I offer a solution. I disagree with several solutions. Who came first, the historical solution. I use Nozick for that one, the historical entitlement, how we may make autonomy possible. And so I deal with several solutions, or these people, these ideal people, they will deal with several solutions. And I come up with one solution. This solution is one of many. Again, to me, the most important part of my 2017 book has to do with the procedure I offer. Equal standing. All participants in a territorial disputes have equal standing, and it is up to them to put a solution. I offer one of the many. By no means I'm telling they should follow the egalitarian shared sovereignty. That would be my advice if they wanted to stop the conflict and if they wanted to bring cooperation. But if they decided to go for autonomy or to go for the Aland Island, I know we have today representatives from Aland Island, or the Hong Kong formula, it's up to them to decide. I'm simply bringing procedural justice to the decision. Something I failed to see, and I'll talk about this later, something I failed to see in the procedures we have right now in public international law. We don't have procedural justice. And in the remedies, that is why I'm not surprised they don't work for Palestine and Israel, or for Kashmir, or for Falklands, or for Gibraltar, because there is no procedural justice. That's a bit of an introduction to set the tone where my work is coming from. Yes, so I started with a solution, ideal, and then it was the time, one of the criticisms from the reviews I had, which I was expecting because it was part of my limitations from my first book, it was highly theoretical. I used 3 cases: Falklands, Malvinas, Kashmir, and Gibraltar, still highly theoretical. That was chapter 8 of my first book. What I decided to do this next step, 2020, I decided to go and deal with cases, real case scenarios. The rest of the presentation has to do with the 2020 book and international relations. This is mainly for political scientists, lawyers, and people interested in international relations. The very first chapter has to do with something I'm familiar with coming from Argentina. I've been teaching again since 1997, and I speak several languages, and my research has to do not only in English, but with other languages. And I'll put an example: the Falklands, Malvinas. I have access to information in Spanish and English, and I can read the information without any kind of emotional attachment or emotional bias, because I don't need translations. Yes, just to put a simple example. What I've observed, just to use this one, the analysis seems to me to be very fragmented. Why? By the methodology, if I'm a lawyer, I'm going to apply, or a jurist, I'm going to apply certain methodologies. If I'm a political scientist, I'm going to apply a different methodology. If I'm a philosopher, if I'm an anthropologist, and so on. So first of all, if I'm going to review a dispute, it has to do with my starting point. And I have to be conscious about my starting point. Because depending on, let's say, my science of reference, my methodology will be the vocabulary I use and the assumptions I bring with me. As a scientist, and I'm talking about, in theory, someone neutral. And then the other fragmented point has to do with the object of analysis. Even Cambridge University Press, that has to do with my research. I put the latest on this book, or Oxford University Press, Yale, Harvard, Stanford. They all focus on one particular dispute. Kashmir, Gibraltar, Israel, Palestine, and the Middle East, the South China Sea, and so on. I fail to see a commonality in this kind of research. So it's either fragmented because of the science or method of reference, or the object of study. I fail to see a global analysis to try to bring conclusions that may be applicable to other disputes. And also to try to not unite, but to try to have a coherent vocabulary when we talk about these issues if we want to solve them, regardless whether I am a jurist or a lawyer, a political scientist, or someone into international relations. So that has to do with my starting point, the fragmentation, and my aim. I'm trying to make something not very coherent into something more cohesive. Two premises. First of all, and this is one of the steps. This is my second step, but not the final step. This is a global analysis, and I'm trying to bring different disciplines. And I'm mainly using law, political sciences, and international relations. And the first few chapters, up to chapter 5, will have to do with concepts and applicable remedies and procedures. What we have now, and my work for the first 5 chapters, is to bring law, political sciences, and international relations together. Yes. The rest of the chapters will have to do with cases. I'm going to think of the Americas, and I'm going to narrow down to some of the ongoing disputes. I'm going to go to Asia, I'm going to go to Africa, I'm going to go to Middle East, and so on, and I'm going to show commonalities in all these disputes I selected. Why these cases and so on, and again, I'm not going to spend time because this is explained in my book, but there is a reason why I selected these cases. Chapter 2, and here you're going to see my view about the multidimensional analysis I propose, facts, norms, and the axiological elements. When we talk about state, we may use the Montevideo Convention definition. A state is a population in a territory with a government. Whether we add law or not, it depends on what kind of definition, more inclusive or more exclusive. But in principle, 3 to 4 essential elements: population, territory, government, or government and law. The thing, depending on whether I'm a lawyer and, or a political scientist, I may bring a different assumption within these definitions. Yes, that is why what I do, I use Hoffeld, a legal theorist that has 2 papers, he died very young, published at Yale, use the term subatomic elements in legal theory. What I do, I simply divide the concept of a state into its smallest components. And these components are not simply population, territory, and government. What I do in law and in political sciences, I go beyond. So I put examples, I select a few examples. It will be impossible, I would need only a book about this particular point. But I use examples of language, ethnicity, and religion for population, territory, I talk about natural resources, defense, and so on, and government, other elements. What I'm trying to show here, when we talk about territorial disputes, sovereignty issues, we cannot simply talk about natural resources. We cannot simply talk about human rights. We cannot simply talk about whether a minority is against or has problems with the majority, or bordering minorities. This is more complex than that. Yes, we seem to always have a unidimensional, that's what I mean by unidimensional. We focus on one element. My proof has to do with the second part of this chapter, the theories. Depending on whether I'm a lawyer or a political scientist, I'm going to use my definition about the state in a different fashion. If I'm a lawyer, state and law, I'm going to use theories centered on territory mainly. That is why the kind of theories we see in law have to do with the original entitlement. That is why my first book, this is not the solution to territorial disputes. The objective theory, subjective, or my favorite, because you know he is my favorite author in legal theory, Kelsen, the pure theory of law. Law and state are the same, yes? That thinking as a lawyer. Thinking as a political scientist, somehow, and I'm not surprised because again, my research has to do with both languages, a political scientist seems to focus on population and government. That is when we talk about the state, we talk about liberalism, Marxism, Weber, Kant, and so on, and the minimal state here from Nozick. Again, I put a sample of the theories just to show or to prove a point. If I'm a lawyer, I agree. Population, territory, and government make a state. If I'm a political scientist, I agree. But then my assumptions, my theories behind my assumptions are completely different, or at least they are not in complete agreement with my colleagues from other disciplines. And then I combine situations. I use examples from Crimea because we have Russian colleagues today. Whether I am a Russian expert, and I have papers written in Russian, and I'm taking over Crimea, I'm simply recognizing my sovereignty. I'm not violating Ukraine's sovereignty. But then if I'm a political scientist from the US or an international relations guy from the US or the UK, I will have a different view. This is an invasion. This is against basic principles in public international law. That has to do, once again, with a unidimensional way of thinking these issues. And finally, I'm not going to talk about this. I have another section. Depending on the element, depending on the theories, we may see different kinds of states. So I started with a very basic definition we tend to teach all our students. People in a territory with a government makes a state. Yeah? And then I see, wait a second, depending on who I am, I'm going to have different assumptions, and that will bring as a result different kinds of states. Yeah? Let me go back to this one here. The next chapter has to do with chapter 3 and the two final key concepts, sovereignty and self-determination. Why I'm bringing self-determination? Because this is the key concept populations, sometimes implanted populations around the world tend to use in order to try to gain their autonomy. The problem with these two concepts, sovereignty has to do with the state as a whole, so population, territory, and government. When we talk about self-determination, it has mainly to do with one of the elements, population only. So they do work together, we need to see how, and that is one of the reasons we need to work together, political scientists, lawyers, and other disciplines. I'm going to probably take more time on the sovereignty part, because this is the best part for me today to show you what I mean by multidimensional view. When we talk about sovereignty, we tend to talk about the exclusive right any government or lawmaker has over a certain territory and for a certain population, whether we talk about a democratic government or not. Yeah, this is roughly a sovereign state or sovereignty applied to international relations. What I do is deconstruct the concept into factual sovereignty, normative sovereignty, and the axiological choice within this sovereignty. And I take each of these elements from the basic definition of a state, population, territory, and government, and I show how it works. In fact, how it works in law, and how it works through the value sovereignty or axiological sovereignty. I'm going to stop here. The example I was putting before about the UK, and I'll talk about this later in the Americas, or France, or Spain, at the time of the empires. They decided to explore the world, and they decided to take over some territories, in principle inhabited. We all know the Holocaust in the Americas and the indigenous populations. That has to do with not recognizing another population as having rights over a territory. And that has to do with an axiological choice. Although at the time when the concept, and I have papers about this, but the concept of sovereignty was already there. It only with Bodin in France and Hobbes in the UK or in England at the time, that we incorporate sovereignty and state together. We have to be conscious, and that's when historians comes handy or comes into place, we have to be conscious about the reality of that historical time. We needed cohesion. Yes. Continental Europe and England, we were struggling sociologically. People were asking for power, whether we have feudalism, whether we have the kings, whether we have the church. Yes. Sovereignty comes because of a historical component at that time. And it had to be absolute, absolute between inverted commas. Yes, between inverted commas. Because even Bodin, if we read the 6 books of the Republic, or Hobbes, the Leviathan, they do include limitations, factual and normative limitations to sovereignty, to sovereign power. So what I'm trying to say here, by showing the factual side and by showing the normative side, I show these limitations, and then it is the axiological choice to decide whether those limitations enable me to have cooperation or domination with others around the world. By means of cooperation, we have United Nations, international treaties, and many other examples. By means of domination, what we have nowadays, and we can talk about law and we can talk about political sciences. I use different examples. This is for political theory. I use not the positive liberty, not the negative liberty, but the Republican liberty, yes, term. In the sense, I can interfere as much as I want somebody else's freedom. Translated to the international world, I can interfere as much as I wish in any other state's affairs, whether internal or external. That's exactly what we have still nowadays in countries in Latin America, in countries in Africa, in countries in Asia, by usually the same international actors, whether the US or Russia, the UK, and so on. In law, we know the United Nations Charter, we are all equal states. In real politics, some states are more equal than others. And I think to me it's very important, that's an axiological choice, that is not part of sovereignty. Yes, I'm here defending sovereignty in the sense that has nothing to do with sovereignty. Yes, it is an axiological choice for any sovereign entity to decide whether they are going to cooperate or they are going to dominate its peers. Yes, the law is very clear internationally. We all have equal sovereign rights over our territories and populations. The fact, the axiological decision I make to decide the future of somebody else's population has to do with my choice about dominating another peer. To finish, I'm not going to talk about self-determination. The only thing I wanted to say, after each chapter, I bring partial conclusions. Yes, and then I finish with my conclusions in chapter 9 for the complete work, for this part of my work, the complete book. What I want to say about self-determination, it does not work against sovereignty. Yes, it's a decision, one of the partial conclusions, that has to be done case by case. It's an erga omnes decision, and it is an ultimate remedium, which means if I cannot, as a population, have any other way to solve my situation, especially minorities, I may claim independence and so on. One thing I want to make clear, and I made clear in my book in 2017 and this one, self-determination means as a population or a group within a population with certain characteristics, people, yes, I am entitled to choose my political status, which means self-determination does not equal autonomy. Self-determination may imply integration, free association, the Hong Kong formula, the Aland Island, it may even be similar as the Antarctic Treaty. Yes, self-determination means my population, as defined in international law, people may choose the political status. Yes, because usually what we see, depending whether we talk with lawyers or with political scientists, self-determination equals autonomy. Big mistake. Self-determination simply entitles my population to choose the political status. It may be autonomy, of course it may be. That is why, to me, self-determination and sovereignty must work together. And I make that point in my book in 2017, because the wishes of the people who live in the disputed territory is paramount. Falkland Islanders, Gibraltarians, Palestinians, and so on, they must be in any negotiations because we are deciding their future and the future of future generations. One question here, and I'm going to address this one later when I talk about the Americas, plantations. We need to distinguish between indigenous population. That's why we have people like David from Finland, because he's an expert on these kind of things. Indigenous populations and plantations, Falkland Islands, or Africans in the Caribbean. Yes, these are plantations, or Israelis and the settlements. Let me go. Territorial dispute. This is the second part of my work. And I'm hoping we are doing fine with because my plan is to finish the chapters and then we go to the conclusions.
That's fine.
Perfect. Again, multi-dimensional view. We cannot think only of the claim. We have, and I put international law here, a list of claims. I bring to international relations, I dare to bring a new concept. I think we need to shake things in international relations and public international law. I borrow a concept from Scotland and the US, colorable claim. Yes, we need surface legitimacy to claim sovereignty. Yes, if I can prove as a state I have a certain right, I may be able to claim sovereignty. I don't mean I am going to be the sovereign. Yes, I'm simply entitled to claim sovereignty. And that has to do with, again, procedural justice, and one of the, for lawyers here, the admissibility stage. Yes, of any procedure. Then we'll discuss if I have ground for my claims, yes? Because what I see, and I put a list here, effective control, historical claim. In reality, I'm Argentina and I'm going to talk about history. Yes? I'm the UK and I'm going to talk about human rights and people living there. So I'm going to have different claims. The problem is we speak a different language, yes? So I'm trying to unite the language and to simply call colorable claim. I have a legitimate reason to claim, then I'm going to be part of the procedure, yes? Issues at stake, that's again part of my multidimensional view. It may be the strategic location of the territory. It may be bordering minorities, but there may be things as the leader's prestige, yes? So it may be as simple as the internal situation in the country makes more profitable and efficient to keep the territorial dispute running, yes, for the sake of the leader's prestige or the political party or the ruling party. Yes, whether we are in a democracy or not. I use Trump as an example. We don't have a territorial dispute with Mexico, but he tends to use the border for political reasons. A very good book here. He talks about Huff from Michigan. Standing your ground, because he brings here statistical data to prove that it's a combination, of issues at stake that may start a conflict or may escalate a territorial dispute into a conflict. And finally, the last part of this book, context. We tend to focus only on one of them, whether we are lawyers, again, international relations experts, or political scientists. We tend to focus on the international context or the rational or the domestic. We need a more complex analysis. When we talk about South China Sea or Kashmir, yes, of course, I need to talk about India, Pakistan, and Kashmir, but it would be very naive, and I'm using naive because I'm very polite, not to include the UK, not to include the US in the analysis. When we talk about South China Sea, yes, of course, I need to talk about China, Vietnam, and the others. But I must include in the analysis Australia, once again the US, and once again the UK. Same, this is very important for the remedies I'm going to talk later. I need to be conscious there is an international context, a regional context, and a domestic context. One lesson I got from the cases I explore in the Americas, it's very important for peacekeeping to have a regional, a local or regional guarantee. Yes. So in the case we have a dispute, it's very normal in Latin America. We are a very peaceful region in that sense. It's very normal in situations between Peru, Colombia, Argentina, Chile. We have usually a regional partner. So it's either Brazil, or it's either Peru, or it's either Argentina as a guarantor for the agreement. Why I'm saying this? we should avoid having external parties to the region. What I mean by external, countries like the UK or the US. This is important in situations like Venezuela as well. Once again, I put here in light blue and white some of the partial conclusions. Again, I don't have time to discuss all of them. So I'm just trying to sum up, you know, the main ones. It's a combination. It's not either or. Yes. And if we need to have a better understanding, we need to have a comprehensive understanding. Dispute settlement, this one will take me a minute. Chapter 5. We have a menu in public international law. We tend to teach this, we've been teaching this forever. I've been teaching since 1997. The reality, again, statistics prove this, they are not very efficient. Very rarely they work. And if they work, very, very few cases go through them. The remedies, I explore public international law mainly in my 2020 book, and possible remedies mainly in 2017, although I mentioned them in 2020. I take the Fortress, NATO, condominium, so unilateral, international, or multilateral approaches, or bilateral approaches. There are always, in key territorial disputes like Kashmir, Gibraltar, Falklands, South China Sea, and so on, there are issues that make them impossible to work. Mainly, again, to sum up, because of this presentation, mainly we will always have the negative of one of the involved parties. If we want to leave the status quo and move to a permanent and peaceful solution, we must take into account, not should, we must take into account all involved parties. That is why this solution do not, unsurprisingly, I'm not surprised they don't work. And we know that, we should be a bit more honest about this. And the last part of this, how are we doing with time, Katarina?
Yeah, it's starting to get time for a break, but maybe you want to proceed to the conclusions, or do you want to...
Can I take 5 more minutes to talk about the 3 chapters, because I'm not going to go into detail, yeah? Sure. 5 more minutes, and then we can move to the conclusions after the break.
Okay.
The chapters before the last, which would be chapter 6, 7, and 8, I bring the cases, yes? So what I do is if I select cases, there is a reason, and I use all the theory from chapters 1 to 5. Yes. So in the Americas, I use the historical element to prove a point. Falklands, Malvinas, or even Mexico, the US, or Guantanamo Bay, the Caribbean, I deal with the San Andres Islands, and the Racial culture, Amazonia, and so on. There is a common root, yes? It has to do with colonialism. The important lesson in this chapter, first of all, we have to identify 2 kinds of population. Again, partial conclusions, I can talk about more, but you know, the ones I want to highlight. Right people in this concept, there is a very good book here, Settlers in Contested Lands. The concept was there about, it's a very good book about this concept, sending people to gain legitimacy. And after gaining legitimacy, I'm going to claim as a sovereign state the legality of my right. Yes, that is very important because that is opposed to indigenous rights. Yes, and it seems we discuss whether Falkland Islanders have the right to self-determination, and we forget about indigenous populations from Canada to Argentina. So that's very puzzling. You know, some people are equal and some people are not that equal in law. The next chapter, Europe and Asia. What I do, again, some of the elements I discuss in, you know, within my conceptual framework, I use in cases in Europe, Crimea, Gibraltar, Cyprus, and Northern Ireland. In Asia, Kashmir and South China Sea. These cases are beautiful. Why? Because Europe, we are all solved. We don't have problems. Yes. The reality, there is a domestic, a regional, and international context. We still have problems, and we have cases of divided societies in all this, the sociological component. In Kashmir and South China Sea, this is very important to keep in mind. There is an international agenda as well. Kashmir, India, and Pakistan won't solve the problem unless they can finish with external influence. yes, or external gains. And I have one thing I wanted to show from the Falkland Islands at the time. I supported the referendum. I was in touch with Falkland Islanders, or in Russia, part of my research published in Russian as well, or in Kashmir. We need to start working more globally with our colleagues from around the world if we want to solve them. And to finish this part, last minute here, Katarina, Africa and the Middle East. That is when I bring everything together. Similar to Latin America, there are historical reasons to conflict and to territorial disputes. Funny enough, in Africa, we still have the presence of France, Spain, and the United Kingdom. In addition to local disputes, yes, but we still have disputes with European states. 2020, we still have disputes with European states. Middle East, Israel, Palestine. Once again, the sociological component, again, sending people, settlers, first of all, to gain presence, and second, in the future, to claim legal rights. We know this as well. And then the international component. So once again, coming back to one of my chapters, many claims, many issues at stake, and the three contexts: the local or domestic, the regional, and the international. And that is me right now. As I said, each chapter has its own conclusion. I've tried to put together more or less the basic language I use and everything else. And and the rest will have to do with the conclusions. Is that okay, Katarina?
Okay, yes, it's fine. I think Mauro wanted to say something before we take a break.
Yes, I wanted to apologize to our partner. There is a standing partner that we have. All these seminars, I didn't want to start a diplomatic war. Sorry, just simply I think I'm starting to get Alzheimer's. I totally forgot. And these seminars are also organized. We always organize this seminar jointly with the Department of Philosophy at the University of Uppsala. So.
Don't worry, Mauro, I say thank you at the beginning, so don't worry.
I know, but now you realize while public international is not my expertise. I thank you for
that is why, thank you for the kind invitation, and that is why I decided to start with 2017, because that is mainly for philosophers.
Perfect. So it is also, I want to thank also the Department of Philosophy at Uppsala University, because all our seminars are jointly done with them.
Yeah, well, yeah, thank you. So I think if we gather again at 5 to 2, so 13:55, and then we will continue to hear Jorge's conclusions, and then we will move on to the discussion. So,
perfect. Thank you very much.
Bye for a moment.